This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about fraud and why presenting as real a free and imaginary oral estimate as proof of a claim can cause an insured to lose his or her or its entire claim, and why false swearing and fraud in a claim presentation voids a policy, because it's never okay to lie to your insurer about the extent of your loss, under oath or just in the presentation of a claim. An insurance coverage dispute that arose from a pipe burst in the historical Pittsfield Building in downtown Chicago on December 17, 2016. Two pipes burst on the 10th floor of the Pittsfield Building, causing water damage to the first 10 floors. After the loss, the Pittsfield Entities filed a claim for the damage with their insurer, the Travelers Indemnity Company, and could not agree on the extent of the damage. In the case entitled Pittsfield Development LLC et al. Versus the Travelers Indemnity Company, a July 3, 2024 decision of the United States District for the District of Illinois, the action and traveler's claim of fraud in the claim presentation discovered during discovery and in the plaintiff's breach of contract suit was resolved. After the initial motion practice and discovery, Travelers amended its answer to assert a counterclaim for breach of contract. Travelers asserted that the Pittsfield Entities intentionally misrepresented their alleged damages by more than $1.1 million, and that the misrepresentations rendered the policy void. At all relevant times, Robert Daniel acted as the sole managing partner and member of the Pittsfield Entities, with authority to direct the activities of all three entities. The policy contains the standard concealment, misrepresentation, or fraud condition that declares the policy void if the insured conceals, misrepresents, or creates a fraud with regard to a claim presentation. After the loss, the Pittsfield Entities hired Joseph Sabag, a licensed public adjuster, to assist them with submitting their claim and preparing their own estimates. Sabag inspected the damage at the Pittsfield Building on June 12, 2017, spending about 5 hours at the property, and then used a computer program called Xactimate to draft an estimate. Sabag estimated the total ACV of the repair and replacement work caused by the water damage at $8,593,203.40. Sabag's estimate included as a line item a bid item from Bluestone Environmental for lead paint and asbestos removal. Travelers, on the other hand, estimated the total loss as a result of the water damage at $401,537.95. After accounting for a $100,000 deductible, Travelers ultimately made payment on the claim of $301,537.95. In the complaint, the Pittsfield Entities alleged that Travelers failed to pay the actual total amount owed under the policy for the water loss event, which they contended was $8,592,961.40, Sabag's estimate. The plaintiffs notably relied upon and included in their pleading Sabag's estimate as an attached exhibit. Daniel testified that Sabag's estimate formed the basis of the Pittsfield Entities' claim for damages, and that he believed it accurately stated the amount they were owed under the policy, less anything that Travelers had already paid. Travelers also deposed Sabag, who testified that this was an oral estimate received over the phone from an employee of Bluestone Environmental, later identified as Tanya Williams. Deposition testimony and declarations from Bluestone Environmental employee Tanya Williams, as well as Bluestone Environmental's president and owner David O'Day, stated that while ballpark or rough estimates were occasionally given verbally, she had not heard of a verbal estimate ever being given for $950,000, and the largest over-the-phone estimate she could recall was in the $20,000 to $25,000 range. It was undisputed that Bluestone has no written record of ever providing a, quote, bid or estimate, written or oral, for the Pittsfield Building. Sabag testified, in fact, that if the Pittsfield Entities had asked him whether to attach his estimate to the complaint to prove damages, he would have told them to get a second opinion. The Pittsfield Entities also disclosed Stephen Harmon, who was submitted as an expert on damages. Harmon based his opinion on his review of Sabag's estimate, conversations with Sabag and Pittsfield, and his review of photographs and other documentary evidence of the damage. Although Harmon could not recall the details of the bid item in his deposition, he reaffirmed that he looked it over and that in his opinion the Pittsfield Entities were owed the $1,235,000 by Travelers for that line item, even though there was nothing for him to look over. Travelers' counterclaim for breach of the insurance policy is governed by the same general standards applicable to any claim for breach of contract under Illinois law. The phrase intentional misrepresentation of material fact does not incorporate the elements of common law fraud and does not require a showing of such things as reliance or prejudice. Instead, all that matters is whether the misrepresentation was calculated to discourage, mislead, or deflect the insurer's investigation on a topic which a reasonable insurer would undeniably attach importance. The court concluded that the Pittsfield Entities did in fact make an intentional and material misrepresentation as a matter of law. The Pittsfield Entities' repeated reliance on that figure, over $1 million, as part of their overall damages, was a material misrepresentation about their claim. The $950,000 oral estimate from Bluestone Environmental was not an actual bid or proposal for work that needed to be done in connection with the water loss event, and in fact, Bluestone never went to the Pittsfield Building and never wrote an estimate. Critically, when asked for their proof of that figure, the Pittsfield Entities claim that they have a proposal from a contractor that says it. Daniel's statement that the Pittsfield Entities had a proposal submitting and substantiating that they were owed $1.14 million is simply false. The Pittsfield Entities misrepresented their damages by boldly and repeatedly asserting that they were entitled to $1,140,000 under the policy for asbestos removal. The Pittsfield Entities' use of this illusory figure to misrepresent their damages did not stop there. Harmon's statements are deeply misleading. The obvious implication from the contention that he reviewed the estimate is that there was some written estimate or proposal for asbestos removal work to review. But there was not, because the estimate, if given at all, was given orally. This testimony that the figure reflects necessary work was simply false. In sum, the court found the Pittsfield entities misrepresented their damages by claiming they were owed $1,140,000 under the policy for asbestos abatement as a result of the water loss event in December of 2016. An insured that willfully makes false statements about their loss with the intent to deceive the insurer is not entitled to recover any amount under their policy, especially after they get sworn testimony from the person allegedly making the estimate that it did not do so, and that its experts couldn't find any estimate to prove that they reviewed it. The Pittsfield entities simply had no basis to cite the Bluestone environmental quote as proof that they were entitled to payment of over $1 million for asbestos removal based on the water damage. The only conclusion that can be drawn from the Pittsfield entities' repeated presentation of this hypothetical quote as proof of their damages, despite the fact that it had no factual connection to work that actually had to be done, is that the Pittsfield entities submitted that false number with the intent of deceiving or misleading travelers into paying that amount. The United States District Court therefore concluded that all the plaintiffs had as proof of their claim was an illusory estimate that they never bothered to verify. Travelers' motion for summary judgment was granted in full, and the Pittsfield entities' motions were denied. The court concluded that the Pittsfield entities violated the terms of the insurance policy by materially misrepresenting the extent of their damage, even after they were shown it was not accurate. Travelers was entitled, therefore, to summary judgment in its favor on its counterclaim as a matter of law, which also required judgment in favor of Travelers. And therefore, since the policy was void, Travelers was awarded damages in the amount of $301,537.95 plus interest and costs, being the amount it had paid in advance of the lawsuit. In my opinion, every lawyer learns shortly after beginning practice that clients sometimes, if not often, lie to their lawyers. When a lie is established by evidence, the lawyer has two choices: withdraw his counsel or amend the litigation to fit the real facts. A competent and honorable lawyer can never present to a court facts it knows or should know are false. After the testimony of Bluestone, Sabag, and Harmon, it should have been clear to the plaintiff's counsel that there was no estimate for removal of asbestos and lead, and that the plaintiff could not prove a right to that money. Instead, they insisted on an entitlement to the imaginary and unprovable loss, and filed a motion for summary judgment seeking those damages, pursuing its demands, which it knew or should have known were fraudulent when first presented to Travelers, and continued and were emphasized with the two experts presented to prove the amount of loss and the testimony of the insured Daniel. The court had no choice but to find that the plaintiff submitted a fraudulent claim for more than $1 million based on a short phone call that was neither a bid nor evidence of damage. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. Thank you for your attention.